Windrush affect people from 65 countries. And those 65 countries can be found on the government website, the Home Office site, and they're listed in alphabetical order from A to Z. Now, what we say to people, the most important thing to understand about Windrush is the Windrush timeline. And the first Windrush generation arrived in the UK in 1948. So since 1948, through the 50s, the 60s, the 70s, and the 80s, people from across the Commonwealth and the rest of the world has come into the UK and have settled in the UK and had their family in the UK. Some have departed from the UK after many years of living in the UK. But the timeline for Windrush is 1948 to 1989. So that gives you a period. And when people talk about Windrush, the first thing we try to identify as to when did you arrive in the UK and what was your status? So if people arrive in the UK in the 40s, 50s, 60s, 70s, and 80s, and they were settled in the UK, then they would be eligible to the scheme. However, if they arrive in the UK in the 90s and the 2000s, then the Windrush scheme is not applicable to those individuals. And those individuals may need immigration advice if they have any issues about their status. And we always make it clear from the outset that we do not give immigration advice on this platform. We are not qualified to give immigration advice. We can signpost individual who may require immigration advice, but we do not give it on this platform. We focus solely on the Windrush compensation scheme. And I can also say we do not focus on reparation, although that is a global conversation at the moment. It is not a conversation that we focus on this platform. There are other platforms where we contribute to that discussion. And we have organizations in the UK who focus on reparation. Pan-African organization focus on reparation. The other thing we need to make clear that the Windrush compensation scheme doesn't deal with racism, because people have said, oh, well, I've been affected by racism in my job, etc., etc. No, there are different mechanisms to deal with racism and discrimination in employment and other services. So we focus solely on the compensation scheme, the scheme that was set up in April 2019. Having said that, as an introduction, let me formally introduce the people on the platform. So my name is Garrick Prayog, one of the members, co-founder for Justice for Windrush Generation. My colleague Roland is also on the platform. Roland, can you introduce yourself, please?
Hi, my name is Roland Housling from Justice for Windrush Generation. Thank you.
Thank you. Can I also mention that the session is being recorded, so if you do not want your photo, keep your camera off, so that we would not you have a choice whether you have your camera on or off. That's entirely up to you. The reason why these sessions are recorded is that information that we discuss on this platform, out on YouTube, people can actually revisit the information and get, some benefit of the conversation that we had today. And you will find a number of our sessions out there on YouTube, including the last international forum that was held on the 30th of December in Jamaica, live from St. Thomas in Jamaica. So do search for those conversations on YouTube. So right at the outset, I've made it clear that our focus today is the Windrush compensation schemes. There are two. And during the next couple of hours, I hope we will be able to give you some information that will help you to have a better understanding of the Windrush compensation scheme, and more importantly, as to who is eligible to apply. So that could be yourself or any member of your family. So the information that you receive today, you can share that information with other people. The other thing that is important that we always suggest, you make your own notes. Some people, will have a pen by their laptop or their computer, and they can make some notes for their own benefit. And so they can go back to those notes, or those notes might prompt a question when the opportunity arises, a question that we hope we'll be able to answer. So welcome again to
Garrett, sorry, Garrett, can I just interrupt?
yeah.
Samsung, can you identify yourself, please?
Yes, it's important that we know who is on the platform. So please put your name and on the device you're using, so we know who's on the platform. Samsung SM A5368. If you could change that to your name, please, it will help.
Or come up on mic and say where you're calling from, please.
You can tell us your name on the mic so we can identify you if you're not able to change your name. I'm not getting a response, Roland, from Samsung.
Okay, continue.
If we're not
Drop
getting a
your mic.
response, we'll have to put them in the waiting room and then ask them to come back in when we identify who they are.
I'll monitor it. Yeah, okay, thanks. Continue, please.
Okay. So it is important that people feel safe on this platform. So we do need to know who's on the platform. And that's why we've asked people to identify themselves. So, as I mentioned, this event is sponsored by Justice for Windrush Generation, operate the second and last Sunday of each month, 2 p.m. till 4 p.m. GMT time. And it goes out across to different time zone. I've established that Windrush timeline starts with 1948 with the first generation. And I've also established that it runs from 1948 to 1989. That is the period that we'll be dealing with this afternoon. The Home Office provide what they call guidance for individual to check if they're eligible to the Windrush compensation scheme. And the guidance is designed to help us to identify whether or not we fit within the period mentioned. So let me just deal with people from the Commonwealth countries, and there are over 54 or so Commonwealth countries. Those people from the Commonwealth country would need to arrive in the UK and settle by the 1st of January 1973. So that would be themselves, their parent, or their grandparent would need to arrive and settle in the UK by the 1st of January 1973. For other people from the rest of the world, they would need to arrive, whether themselves, their parent, or their grandparent, they would need to arrive and settle in the UK by 1988, December 1988. Sometime we say the 1st of January 1989, end of the year, first day in the new year. So they would need to arrive and settle in the UK by December 1988 from a non-Commonwealth country. As I mentioned, Windrush affect people from 65 countries. And so there are many people who do not know that they're part of the Windrush population. And we find when we talk to people from Africa, people from Asia, India, Pakistan, Bangladesh, they didn't know or don't know that they're part of Windrush. And they often say to me that Windrush is a Caribbean issue. And I understand why they would say that, because the images that they see from the original generation coming off the ship were Caribbean people, Jamaican people. They did not see any African person coming off the ship, nor did they see any of the 65 Polish people that was on the ship. All they saw was black faces and restricted to Caribbean people. So they draw the conclusion Windrush is a Caribbean issue. So when you have conversation with people, just put them right. It is not a Caribbean issue. And we often say Windrush is a global issue affecting 65 countries. Having said that, then I'm going to focus now on different elements of Windrush claim. So we establish the timeline from 1948 to 1989. We've established a timeline, and we're now going to break it down into who is eligible to apply to either rectifying their status, getting their papers, or if they've been impacted. And what that means, if you've been impacted, if you suffer loss due to the fact that you could not prove and evidence you had the right to be in the UK, when you were asked to produce document, you did not have document to produce. And as a result of not able to produce document to show your right to be in the UK, to work and live in the UK, then you would have suffered losses. And we'll talk about what that is in terms of discussing compensation scheme. Okay. So reading directly from the guidance under the heading of eligibility, you can apply for the scheme if you have losses because you could not prove your right to stay in the UK. You had losses because you or the partner, child, brother, sister, or parents of someone who could not prove their right to stay in the UK. You represent the estate of someone who had losses because they could not prove their right to stay in the UK. So you notice those 3 bullet points. Yeah. The guidance break down the difference between a primary claimant, the individual making the claim. Then it talks about close family claim. That's a separate claim, individual close family supporting a primary claimant. And then finally, it talks about a deceased estate claim, somebody who was eligible but died before they're able to submit their claim. That is called a deceased estate claim. So let's go back to the primary claimant, the individual who has checked their eligibility and they are eligible because they come from a Commonwealth country and they arrive and settled in the UK by the 1st of January 1973. So they've got the green light that they are eligible to make an application. However, what we don't know is whether that individual who is eligible has suffered losses. And when we talk about suffering loss, what is meant by suffering loss? You were impacted, and there are different words that the Home Office use in its guidance. Suffer loss, or you were impacted. The fact that you could not produce documentation evidence when you were asked to bring your passport in to your employer, bring your passport to the local authority for housing, bring your passport in for other identification. You could not produce that because you did not have it. Although you've been living in the UK probably from a child. You did not have those documents. As a result of not having any document, you were greatly impacted. You suffer losses. And so that is a difference between being eligible to the scheme. Not everyone would have suffered losses, but those who have suffered losses can make a compensation claim. Compensation claim may span over many years. Let me give an example. You may have been working for an employer in the 60s or 70s, because during those periods, employers did not ask for any documentation. They gave you the job and you were an employee. But later on, as time went on, the government introduced a new pieces of legislation that require employers and other public bodies to check who is eligible to work in the UK and who is eligible to access public resources. So you may have been in a job for 25 years and there was no issue until the employer now called Mr. Smith and Mr. Smith to come into the office and can you bring your passport in tomorrow? Because this was instruction from the government. 10 years earlier or 20 years earlier, that was not the case. But now it is the case that they're wanting to check if you have the right to work in the UK. And because you do not or you did not have a passport to bring in the next day, the employer had to dismiss you. And while you were dismissed, you're thinking, well, I could find another job. But when you apply for other jobs, you come against the same situation. Can you bring your passport in? You haven't got one. And wherever you go now, that is the requirement. I use employment as one example. There are many other examples. You may have had a bank account and now the bank asks you to bring documentation in. You cannot, they close your account. You may have a mortgage that you were paying for, and the same situation, the mortgage people ask for the documentation and proof you haven't got it, and so you lost your house. Losing your house, you now have multiple issues because you're not able to find rented accommodation anywhere because, again, documentation is required as proof you have the right to live and work in the UK. Bring your passport in, please. You haven't got it. Now, we know of real stories of many people who've experienced those issues, and even now, those issues have not been resolved because they are still fighting for their compensation claim. So when the Home Office used the term, have you suffered losses or you've been impacted, there's an example of people who have suffered losses as a result of not able to prove their lawful status or have the right to be here in the UK. Some of these people may have born in the UK from parents of the Commonwealth. Some may arrive in the UK as children on somebody else's passport. It wasn't required for a child to have his own passport. When you got to 18 or 20 and you try to apply for a passport, it's refused and you don't know why. Can I say at this point, many individuals who make an application for a British passport and it is refused, and they trace it back to the fact that the parent of the individual did not have the right of abode, did not have the uh, status, or did not even apply to get their status corrected. Because many of the older generation believed that because they had a British passport when they left their Commonwealth country in the 50s and 60s, because they had that passport, they believed that they were British and there was no need to do anything. And so by not doing anything, that has impacted on their children. And many of the people that came under the Commonwealth, when those countries gained independence, then those individuals who had the British passport revert back to the nationality of the country of birth. In my case, it would go back to Jamaica, because 1962, Jamaica gained independence. So there's been a lot of misunderstanding, particularly around the older people who thought, I had a British passport, I don't need to do anything. And by not doing anything, they didn't know it would impact on their children. Talked about people from the Commonwealth. We talk about people who had to produce document and they could not produce the document. So as a result of not able to produce the document, they have suffered losses or they've been impacted. And that is where the compensation claim comes in. However, the Windrush compensation scheme also was set up for individual to rectify their status. In other words, to get their documentation. And many people have corrected their status, but they didn't have a claim for compensation because they did not suffer any losses. If you look at the data that the Home Office produced, which is out in the public domain, it gives you a list of countries who make an application on the Windrush scheme, and they're listed as to how many people have successfully gained access to status or to rectify their status. And if you look at the data, what you will see that EU national is the greatest number of people benefiting from the Windrush compensation scheme, because Brexit came and European has been living in the UK for X amount of years, and they had the right to rectify their status under the Windrush scheme, and almost 5,000 EU national have done that. So you will see from the data, the greatest number of people benefiting from the Windrush compensation scheme is EU national after Brexit. I'll pause there for a moment before I move on to anything else. Is there any question on what I've said so far? What I'd like to do now is to highlight another element of the scheme. We talk about the primary claimant is the individual making the claim. And again, we emphasize that each of the claim comes with guidance. So for primary claimant, you have guidance. You have to read and follow the guidance before you make the application. We always recommend an individual to read the guidance over and over, right, before they make the application. And we always recommend, before you put anything on paper, do a rough draft of the answers to the question using the guidance. And when you are happy with the rough draft, before you put it on the final application, get somebody to look over that application and how you've answered those questions. Get somebody to look over and check before you submit the application to the Home Office, who the caseworkers will then go through that and make a decision on your application. And we keep emphasizing not everyone can read the guidance and fill out the application, answering all the questions, and then answer the question in such a way that when the Home Office caseworkers read your application, they are convinced you've been impacted, you've suffered loss, and they will award you, a payment, which we don't know what that will be. But we also know that many application has come back with a nil award. And the reason why many application has come back with a nil award is because the question asks about how you've been impacted, and there was not sufficient evidence, information put on the paper for the caseworkers to assess that you have suffered those losses. And so a nil award has come back. And we believe that if an individual had taken time to carefully make that application, to consult, and also, more importantly, to seek help from an advocate. And there are a number of organizations around the country that offer advocacy. If people had taken the time to reach out to any advocacy support, then the application would not return as a nil application, because there hasn't been sufficient information given as to losses. Let me give you one example, what often is overlooked. There are 13 different heads of claim. People often have to go through each of those to see whether those have affected them. Sometimes only 6 or 7 heads of claim is applicable to one individual. For example, there's a question that says, have you been detained? detention, deportation, and a person may think, I've not been deported, so I don't need to say anything in that answer. But also, many of us, when we travel in and out of the UK, coming back at the airport, immigration officers will stop you and will question you as to where you've been, what's your intention, why did you go to where you travel? And you may have been held up by immigration office for 40 minutes, 45 minutes before you've been given the go-ahead to get through clearance. Now, often that 45 minutes at the airport with immigration officers, people don't put that on their claim form. And we say to people, anything over 35 minutes, you've been detained, it needs to be recorded on your claim form as part of your claim. That's one example. When individuals who have suffered losses, they have suffered emotionally, psychologically, as a result of the change that has happened to their family life, their situation, losing their job, losing their house, losing their benefit. All these things has impacted on the individual. And what do you think will happen to your state of mind and your mental state? We know of individuals who've been committed to a mental health hospital for a period of time as a result of what has happened to them. Again, when you're making your claim, those things have to be put on your claim. If you've been unable to go to university because, again, you did not have the document to show, so you lost your university place, again, that should be put on your claim. Housing, again, that should be put on your claim. And the guidance is there to assist you. Each of the question, you consult the guidance as to how you should answer that question and give example of the losses that you have suffered. If you skip over the losses and you submit your application, the caseworker is going to read your application and will conclude that you have not suffered any loss because you have not disclosed it. So when you get a nil return claim and you think, why is it that they did not give me an award? It's because of the information that you've put on the application. So it's important before you submit your application, get some help. Whether friends, family, or somebody that is completely impartial, separate from anything, the advocacy support, reach out to them and get some help with your application. And we know not everybody can read and then follow the instruction and put the answers in. Some people have got challenges, many challenges that they find it difficult to deal with those things. Literacy and numeracy, all these issues, and learning disability, all these issues will impact on an individual. So please reach out for some help. Don't just send the application in without somebody checking it over. And Jackie McKenzie came on our international forum just over 2 weeks ago. And what she said, all the cases that is sent through by lawyers, the Home Office never argue with those cases, and their claim, they always get the maximum for their client because a lawyer has presented the claim. However, the person who would do it themselves will not get the same result. So please reach out for help. And don't think, you can do it on your own. Even just to look over it, it may be okay just for somebody to look over and ask you a few questions. Well, what about this? What happened here? You can get a little bit more help if you speak to somebody and reach out to somebody. So that's about primary claimants making a claim and making sure that your claim as a primary claimant, each of the elements, you answer those questions convincingly, that the caseworkers, when assessing your claim, will say, yes, yeah, they've suffered loss as a result. They could not prove their lawful status. I'm going to pause there, and I'm going to move now into another aspect called close family claim. Close family claim is for individual who have supported a primary claimant. The person who lost their job, lost their house, lost everything, and family members and friends been supporting this individual family for X amount of years, supporting emotionally and supporting physically and monetary. That's close family claim. And close family claim, there is no fixed number as to how many individual can support a primary claimant. I'm going to ask Roland now to come in and tell us who is eligible as a close family claim. Roland?
Gary, can you hear me okay?
Yes,
Can you hear me okay, Gary?
I can.
Okay, there's some background noise beyond my control. If it becomes too irritating or annoying, I probably gonna have to hand back to you.
Okay. Well,
Good
if you can.
afternoon, everyone, wherever in the world you're joining from. So Gary spoke about primary claim and who is eligible to apply and the possibility or what would make you entitled to compensation. In order for you to be eligible as a close family member to apply, you need to be fit in 6 particular groups of family members and be close family member of the deceased, primary claimant or a eligible and entitled deceased estate. There's no difference between the primary claim and the deceased estate claim, except that that individual who would have been eligible and entitled to compensation is now deceased, consequently, a deceased estate claim, close family member claim. You can apply as a close family member if you're a close family member of the deceased or a primary claimant and you fit into any one of the following groups. Wife or husband of the primary claimant are deceased. Parent of, children of, siblings of, stepchildren and step-parent of, are cohabitee that has lived with the primary claimant and are deceased while they were going through the struggle and they have lived together, cohabit for 2 years or more. There's not, didn't mention any number, didn't say to a maximum of 10 or 5 or whatever. So if you've got 10 siblings, 50 children, your mother or your parent about to life, also all the siblings, all the children, parent, and your wife or partner, cohabitee is also still alive, they can all make a claim. You do not need to have been supporting the primary claimant in order for you to make a claim as a close family member. You don't need to have supported the primary or the deceased individual to make a claim, because the two primary elements of the close family member claim, there is impact on life and also living expenses. Say living expenses. If you have supported that individual financially, give them money to buy food, phone cards, money to go into emergency shelter, etc., or you invited them in your home, then your utility bill would have gone up. That is living expenses. But there's also impact on life. In order for you to be entitled for compensation for impact on life, you do not need to have supported the primary claimant. It's how you are impacted emotionally, anxiety, stress, etc., due to you seeing your close family member going through that they were going through, experiencing the hostile environment. They were stressed, depressed, anxious, etc. And that caused you, the close family member, whether it be the wife or the husband or stepchildren, etc., after that primary claimant caused you to be stressed and anxious. And I've got cases where the close family member was that stressed that they had to seek consultation for the mental health from the GP or any other professional, counselor, etc. In some cases, that cases where the individual was that impacted, the close family member was that impacted by what they were seeing and what was going on around them, the chaos, the disruption that was going on, or the primary claimant was experiencing, that they had a visit from a mental health practitioner, a visit to their home. That's how much their mental health was impacted. Even had cases where individual close family member ended up in a mental institution due to what was happening to the primary claimant. In this particular case, it was their mother. So I said no numbers. There's a limited number how many can apply. I've had cases where there are 15, 16 close family members applying on the back of one primary claim. So I'll hand back to you at this stage, Gary. Just before I go quickly.
Yeah, go ahead.
They need to provide evidence to demonstrate how you are related to the primary claimant or the deceased individual. So you have a child of, then you'll need to provide birth certificate to establish how you're related to the primary claimant, whether it's a brother or it's a parent. If you are a stepchild or a step parent of the primary claimant or the deceased individual, children, you need to establish that you, the child, know no other parent. Or for instance, a father, a stepfather, you knew no other father than this one, than the primary claimant. So you were growing up, while you were growing up, that is the father that was around you, so to speak. Likewise, if it's step parents.
Your volume is a bit low. Just bring your volume up a bit, Roland.
If I bring the device a bit closer. If you are a cohabitee, then you need to establish that you are living together at the same location while the individual were going through the struggle, or you may have had children with the individual. So it needs to be evidence, and there are various ways of going about gathering evidence, especially in a situation where it's a stepchild or step parent. That's the most challenging one in most cases. But there are many ways of evidencing that. School records or the step parent, you may have visited the hospital and that step parent signed documentation giving permission for you, I don't know, to have your teeth removed, etc., etc. Or you had letters from his school when you were younger, 7, 8 years old, coming to that same address while that stepfather, stepmother was living there. So they were your step parent or your only parent, so to speak. I'll hand back to you at this stage, Gary. Any clarification,
Thank you. Thank you,
explanation,
Roland.
elaboration, etc. I am here. Thank you very much. Back to you again.
Yes, thank you. I'm just going to add a few additional points to what Roland said with regards to close family claim. And again, we mentioned guidance. So to make a close family claim, you must consult the guidance. The guidance will help you. Each of the question, there will be a section relating to the question where the guidance will help you to formulate your answer. Right? It's important that you consult the guidance when you're making the application, whether primary, close family, or deceased. Do not fill the form in without reading through the guidance relating to that claim. Very important. The other thing I should mention, if the person is under the age of 18, they cannot make a close family claim. They need a parent or a guardian to submit the claim on their behalf if they're under the age of 18. And we do know that even currently, there are many youngster children caring for family members. Many children are losing out on their education in this country because they're caring for other sick family member. Yeah? And often they are overlooked. The service that they provide, the help and support that they provide on a voluntary basis, they don't get paid for doing that. We sometimes hear about young carers. Young carers do a lot for their family, parents and grandparents, and there is no payment for that. So if you're under the age of 18 and you are caring and supporting, then you cannot make the application. The parent or the guardian would submit the application on your behalf. That's important. The other thing that we need to stress around close family claim, we're not seeing enough close family claim submitted. And I don't know if the reason is because people think it's too complicated, they don't understand. But a lot of people who've been supporting other family members are losing out by not making a close family claim. And can I stress, the offer, the offer that is made to the primary claimant does not affect any close family claim award. If the primary claimant been awarded £80,000, it is of no consequence and will not impact on the close family claim that may award £40,000, right? So don't think if you make a close family claim, you will be reducing the money going to the primary claimant. That is not the case. So please do not use that as a way of saying, I'm not making a claim because the other person may lose out or get less money. That is not the case. The other thing that Roland didn't mention is when a close family claim is ready to be submitted, it is important that the primary claimant is aware of a close family claim being submitted. It would be strange if a close family claim is submitted and the primary claimant says, I don't know who this person is, or this person has never helped me. So conversation needs to take place between the primary claimant and the close family members who've been helping them, that I will be making a claim. When we always say this, as soon as an offer is made to the primary claimant, doesn't matter what the offer is, yeah, it could be £1, doesn't matter what the offer is. As soon as an offer is made, then the close family claim should be submitted, not before the offer. As soon as the offer is made, the green light that you can submit your close family claim. Roland?
Something quickly. The close family member do not need to have supported the primary claim. They don't need to have supported them financially. They don't need to have been engaging, interacting, etc., etc. They could have just sit back, shut on the fence, and observe what was going on, and that impacted them emotionally, stress, anxiety, etc., etc. It's very important. You do not need to have supported the primary claimant financially for you to claim impact in life. So your impact,
Impact on life bit, yes.
etc.
Yes, yes. The impact on life bit is important, because that has affected you, seeing what your auntie, your brother, your sister, your uncle, your father, your mother is going through. That has impact on you. So that's very important. And please, if you require any more information regarding close family claim, please reach out. Roland has done a number of these, a close family claim. And so, he's quite experienced in dealing with close family claim. Any question offline, please, reach out. You can look at our website, which is justiceforwindrushgenerations.co.uk. There you will find WhatsApp number, email address that you can reach out to any one of us in relation to not just close family claim, but there's also the full eligibility information on our website, who is eligible. We break down primary claimant, we break down close family claim, we break down deceased estate claim. They're all there in one place on our website. Okay? They're all there with the guidance and everything. It's all there. justiceforwindrushgenerations.co.uk. You can visit that in your own time and read each of those claim elements. So we spoke about the primary claimant, and we spoke about close family claim. And the deceased estate, there is no difference between deceased estate claim and the primary claimant. It's exactly the same, except the family claim is now been taken over. The deceased estate is now submitted by the person who has the right, the executor, the person who's dealing with the family estate. That person will make or submit the claim on behalf of the person as a deceased estate claim. Now, what's important with the deceased estate claim is that the Home Office will need, confirmation, written confirmation, document to show that the person responsible as the representative of the estate, that person have the legal responsibility to provide the evidence of the deceased. And the Home Office will assist with costs to get the document, the legal document, to confirm that the person is deceased. We can't just write on paper that the person is deceased without any proof, because we could be telling lies. The Home Office want the documentation with the death certificate, the documentation to confirm that the person is deceased. And that would be the legal representative or the representative of the estate. In each country, the terminology might be different. But it does provide the same outcome. The person who will administer the estate on behalf of the deceased, who has the legal right, executor has a legal right, that will be the person who provide the Home Office with the necessary documentary evidence. And the Home Office will pay up to £1,500 to the individual to get the documentation proof. Yeah? So don't worry that, oh, I have to get this, I have to pay for this, right? Again, the Home Office will cover the cost, but you need to reach out to them and they will assist you at the cost of getting the proof that the person is deceased. Once they get that, they can start to process the application. That is very important. Without that, the deceased estate application will not be processed. Now, the other thing that we need to emphasize is that recently the Home Office has updated the application form. We must make sure that we're using the correct and up-to-date version of the application. And the current version is version 18.0. So make sure that when you Google Windrush compensation scheme, that you make sure the document you're looking at is the up-to-date version 18.0. The previous one was 17. This is version 18. Use the correct information. That will speed things up. Just to emphasize, there are no fee for application on the Windrush. You don't have to pay anything. It's a free scheme. You don't make any payments. If you go to an immigration lawyer, you have to pay money. There's no payment with the scheme. Let me just read directly from the guidance how to apply. An application under the Windrush scheme must be made on the relevant form on gov.uk, the Windrush Compensation Application UK, for applicants living in the UK, or the Windrush scheme application overseas for applicant living outside the UK. Notice the point. There is one for living in the UK and there is one for applicant living outside the UK. So if we're outside the UK in any of the Commonwealth country or the rest of the world, make sure we're using the right application. Yeah? There is a distinction. There are no fees at all. So the whole process is free. Let me just read a couple of paragraphs from the guidance. An application under the Windrush scheme will be considered under the existing law and policy. But if the policy set out in this document differ from the existing policy in this document will, sorry, but if policies set out on this document differ from the existing policy in this document will be applied. The Windrush Help Team will consider the application on the ground based on all the evidence available, including from Home Office records, those of other government departments. So the Home Office will get information from other government departments to verify what you've said in terms of, when you lost your job, when taxation stopped being collected, when national insurance stopped being collected. All this information, the Home Office have got access to get this information from other government departments. So again, it's important that what you're putting on paper is accurate to the best of your knowledge, because they will check and they will cross-check. And if you say you lost your job in 1974 and you didn't have a job at all, they will know. See? So it's important that the information is correct. Reading on, no information provided in relation to an application under the Windrush scheme will be passed to immigration enforcement. I don't believe that. I've challenged the minister over this directly, and I don't believe that. They say this on paper. I don't believe it. Again, we see. The Windrush Help Team will not consider any application which fall outside the scope of the scheme as set out in this document. Notice right at the outset, I talk about dates. It's important to establish when an individual arrived in the UK, when they were settled in the UK, and from what country they arrived, whether a Commonwealth country or a non-Commonwealth country. It's important. And if the individual arrive and settle in the UK after or outside the dates, then they're outside this scheme. And I give the example, if you arrive in 1991 and 2000 from any parts of the world, you're outside Windrush compensation scheme, because the scheme operated from 1948 up to 1989. That is the Windrush timeline. Very important that you fit into that. And finally, the last paragraph, a definition of the nationalities and of group included under the Commonwealth citizen for the purpose of scheme is included at the end of this document. So when you go through the guidance, you will see all the countries listed from A to Z. They're all there. And we always made reference to the full guidance. The full guidance is a lot of reading, but it is the caseworker's Bible. The caseworkers will be using this caseworker's full guidance. They'll be using this to assess your application. So you have to read and know what is contained in the caseworker's guidance. Why? Because the caseworkers will assess your application, and if they've assessed your application under the section of, shall we say, employment, and you don't know how they arrive at that decision, because you haven't consulted the guidance, you're not able to challenge that because you don't know what they've done. What we say to people, that we know there are cases where the case workers have not, let me emphasize, have not followed their own guidance, and we have challenged them on that, and we can pull them up because they have not followed it. Only because we have followed it and we know what it says that we're able to challenge them. For those people who don't know, they will not be able to challenge them. So please, the caseworker's guidance is a very important document. It's a lot of reading. It's over 100 pages, but you can cross-reference each element of your claim. You can cross-reference so you know what the caseworkers will be looking for in your responses. Very important. Don't just fill the application without consulting the guidance and, of course, the full guidance. And a person in the UK, remember, it makes the distinction between those applying from inside the UK and those applying from outside the UK. And this is what it says straight from the guidance. A person in the UK, a Commonwealth citizen who has either settled in the UK before the 1st of January 1973 and has been, listen to the word, continuously resident in the UK since their arrival, or has the right of abode. Let me read this again. A Commonwealth citizen who was either settled in the UK before the 1st of January 1973 and has been continuously resident in the UK since their arrival, or has the right of abode. And then here's the bullet point. The Windrush Help Team will consider whether the applicant is already a British citizen, and if they are, they will be given a document confirming that. If the applicant is not British and has said on the application that they want to become British citizen, they will be considered for naturalization under the British Nationality Act of 1981. Thirdly, applicants who were settled in the UK on the 1st of January and those with the right of abode who have strong ties to the UK will be taken to have sufficient knowledge of English and of life in the UK, and so the requirement to pass the life in the UK test will not apply to them. Let me read that paragraph again. So there are some people who will have to go through a test, a life in test in the UK, but listen, who will be exempt from this. An applicant who settled in the UK on the 1st of January 1973, and those with the right of abode who have strong ties to the UK, family members still living in the UK, have a house in the UK, may have a business, have strong ties with the UK, will be taken to have sufficient knowledge of English and life in the UK. And so the requirement to pass the life in the UK test will not apply to them. They will also not need to attend the citizenship ceremony unless they want to. Very important. Finally, the application have to meet the resident requirement for citizenship and the good character requirement. If the applicant apply for British citizenship, they will be given a certificate of naturalization. If the applicant does not apply to British citizenship or does not qualify for naturalization, the Windrush Help Team will consider whether they have the right of abode. And if so, they will be given a document confirming the right of abode. And finally, if not, the Windrush Help Team will consider whether they are entitled to remain in the UK, and if so, they will be issued a grant of no time limit, NTL. Is there any question on what I've just read from the guidance? And don't forget, we've said that those people from the Commonwealth country, when their country gain independence, they revert back to being national of that country. Okay? So from the 60s and 70s, nations from the Commonwealth were gaining independence, and so they fall back to the nationality of the country of birth. And this was one of the issues that the older generation did not understand, because they felt that they had a British passport and it was indefinite. Nothing would happen. It will stay like that all their life. And that's not the case. And I've made the point that your parent and your grandparent status is important. Some people discover when they make an application for a British passport, that is when they discover that their parent or their grandparents did not have a status. In other words, the parents and grandparents did not apply for British status, nationality. And some families don't know whether their parents had a status because their parents might have died when they were a child. And those individuals were born in the UK from parents from outside the UK, Commonwealth, and the rest of the world. Often it is the case when they make an application for a passport, that is when red flags appear. But that is when the Home Office really start to dig into the family to find out what the history of the family and their status going back to parents and grandparents. So don't be surprised if when you make an application, you get a refusal and you don't know why. And you think to yourself, well, I'm born in the UK, but you don't know about your parents. What was their situation? So what we've done this afternoon, we've covered the Windrush timeline from 1948 to 1989. We've talked about those from a Commonwealth country, and they need to be in the UK settled by the 1st of January 1973. And then we talk about those from non-Commonwealth country. They had to settle in the UK by December 1988. We then talk about primary claimant making a claim. That's the individual making the claim. Roland spoke about close family claims. And he made a point of you don't have to, the point that was made of the close family claim, the impact on life element that you've experienced, that bit of the claim, you don't have to. Can I just re-emphasize that point, Roland? Because I want that to be firmly established. The impact on life element of the close family claim. Just repeat what you said, please.
You do not need to have support to the primary claim, whether financially, emotionally, etc., etc. You don't need to have been even engaging with them in order for you to make a claim as a close family member.
Okay, so you hear that.
And observe what was happening. You do not support them. You did not support them financially, emotionally, etc., etc. Not because you have not supported them, that does not mean you were not impacted, have not been impacted. The impact on life element for close family member is about you, the close family member, how you were impacted due to what you saw the primary claimant or the deceased individual going through. Everybody reacts and deal with trauma differently. Okay, some people may have broken down in tears, etc., etc. Others that were observed, etc., etc. Okay, and back to you. Thank you.
Yes, thank you. And so I want to now focus on another element that is really a big concern. There are individuals who had the right, living in the UK for many, many years, and then they had to leave the UK to visit family members for various reasons. And as a result of leaving the UK, they have been out of the UK for more than 2 years and 1 day. And as a result of that, they are not able to come back. Their status has lapsed. And that's because the immigration rule stated that if you leave the UK for more than 2 years, your status would have lapsed and you cannot re-enter the UK. That is still part of the law. That hasn't changed. That is, they're still using that, the 1971 Act that became Law 73. You've heard the expression that people have been locked out of the UK. There are thousands of people locked out of the UK and cannot re-enter the UK. The example that I can give that's been in the public domain is a gentleman by the name of Richard Black. And Richard Black has been out of the UK for many, many years. And only last year, he was able to come back to the UK after a very long campaign. And we know that there are people still, when we had the event in Jamaica just a few weeks ago, this was one of the points that we were raising about people living in the Commonwealth countries that not all of them would want to come back to the UK, because some of them, because of their age, they do not want to come back to a cold country. But there are many of those who want to come back because they have family members still in the UK, so they still have ties to the UK. but because of the 2-year rule, as it were, they are not able to. Now, we've been pushing this point about returning resident visa. So individual can apply to come back to the UK through the returning resident visa application. Roland, can you just say something about that, please?
For those who have lost their indefinite leave to remain due to the fact that they've been out of the UK for 2 years or more, if they've got strong and continuous ties to the UK, family members, brothers, sisters, children, etc., they can apply for a returning resident visa to return to the UK and continue living as they were living before. So
Yes.
strong and continuous ties, they can apply for a returning resident visa if the indefinite leave to remain lapse due to the fact they've been out of the UK for 2 years or more. Just to clarify on something.
Roland, just keep talking. I'm just going to go to the bathroom. Just keep talking for a minute, and I'll be back in a second.
Yeah, we have come across a number of cases in Jamaica and across the world where individuals with right of abort have been denied entry to the UK. That is different from those who have indefinite leave to remain and were out of the UK for more than 2 years and their indefinite leave to remain lapsed. Earlier on, I think Gary touched on those applying for compensation from outside the UK that have to or should regularize the status before they apply for compensation. In fact, it actually stipulates that to an extent in the guidance note that you should regularize the status first before you apply for compensation. But in the case of those who has got right of abort, like one particular gentleman I came across in Jamaica at the International Forum on the 30th of December. He had a right of abort, was born in Nigeria, an English mother, Jamaican father, was born in Nigeria, entered the UK in the 60s, lived in the UK from the 60s till about 78. When he started to live in Jamaica. And was living in Jamaica from 78 all along, back and forth with his right of abort, had no issue. However, in August last year, 2024, he was denied entry to the UK despite the fact of him having right of abort. I say all that to say this, that there are numerous individuals that have been denied entry to the UK for various reasons. You have individuals that were born in the UK and have British passport that was denied entry to the UK. In that particular case, they had the British passport expired and passport office chose not to renew it. And we got other cases as well. One particular individual that was also common in October, Nigerian gentleman was born in the UK and he literally had to break back into the UK, so to speak. He had to enter the UK on the back of a lorry. And at one point, did a number of times, and at one point, he was deported from the UK, despite the fact that he was born in the UK. And then he re-entered the UK some years later as a refugee, and he entered about November, and the following June, they said they had made a mistake. He had a right to be in the UK all along, and they issued him with a British passport. There are numerous cases where individuals have been denied re-entry or entry to the UK when they had the right to be in the UK all along. Back to you, Jeff. Thank you.
Thank you for that, Roland. So for the next 10 minutes or so, I'm just going to focus now on this issue about those who are locked out of the UK where the indefinite leave to remain has lapsed. And I'm going to read directly from the guidance. And this is the guidance from caseworkers, which is the information they'll be using to assess your application. A Commonwealth citizen who was settled in the UK before the 1st of January 1973, whose settled status lapsed because they left the UK for a period of more than 2 years, and who is now lawfully in the UK and who has strong ties to the UK. Listen to the bullet point. If the applicant is currently lawfully in the UK and not liable to deportation on grounds of criminality or other non-conducive behavior, and has strong ties with the UK, they will be given indefinite leave to remain. Due to a mistake in previous version of the Home Office guidance, some applicant who lost settlement status as a result of absent for more than 2 years prior to the 1st of August 1990 and who returned to the UK on some other form of limited leave by that date and have lived in the UK continuously since may previously have been issued a no time limit NTL document despite not actually having indefinite leave to remain in law. Where such case are identified, they will be treated as falling under this eligible, can't even say the word, eligible group of scheme will be considered for a grant of indefinite leave to remain. If the applicant is already settled and want British citizenship, they will be considered for naturalization under British Nationality Act 1981 in accordance with residence and good character requirement. Applicants who were settled in the UK on the 1st of January 1973 will be given to have sufficient knowledge of English life, and they don't require to go through the English test, etc. However, this point, a child of a Commonwealth parents where the parent either was settled in the UK before the 1st of January 1973 or has the right of abode who was ordinary resident in the UK on the date did not satisfy the provision and is now a British citizen, including citizen who satisfy one of the requirements and is now deceased, and where the child either was born in the UK or arrived before they were 18, was not automatically British citizen or citizen of the UK colonies from birth, and has been continuously resident in the UK since birth or arrival. What I'm reading from is the document that I continue to refer to, because this is the document, the caseworkers guidance document that they will be using to assess your application. So it's good to get familiar with this document, the words that is used in this document, the different parts of the Immigration Act, whether it's 1981, whether it's 1973, they're all quoted, the reference are there. So again, be familiar with this document. Use it as a reference. Back and forth. Use it as a reference to answer question appropriate to your application. And finally, where the parent died before the 1st of January 1973, it is sufficient that they were settled in the UK before their death. So the point is, where they died before 1973, it is sufficient that they were settled in the UK before their death. That's how they conclude on that. Quite straightforward. And then it talks about the Windrush help team is there to assist you with any query. However, it also says if you're not entitled to register as a British citizen, you will be considered for naturalization under the British Nationality Act of 1981. Applicants whose parent was settled in the UK before January 1973, or those parents who had a right of abode, who had strong ties to UK, will be given to have sufficient knowledge of English, will not go through the English test and the good character test. Again, this information is in the public domain. Everyone can access the guidance. Make sure the guidance that you are using is correct. Make sure the version that you're using is the latest version, 18.0. Make sure the application that you're using is the latest application because it was updated. So always check. If you're not sure, find out, seek some help. That you're using the correct information, the latest information for your application. I'll pause there for a moment. Is there any question? What I want to do now, just before we conclude, we've got a few minutes, about 9 minutes or so. I'm going to now give you some update information on what's coming up in the next couple of weeks, couple of months with regards to campaigning work. So, Roland, can I bring you in now to tell the audience what's happening on the 22nd of January?
Yeah. The 22nd of January, we will be at the House of Commons for the next Windrush rally. We've been doing this for going 3 years now to get changes to the Windrush scheme because the scheme as it is not fit for purpose. We've got a number of speakers already confirmed. Hopefully within the next 2 days, we'll have others confirmed as well. We'll be focusing on primarily the promise that were made by the current Prime Minister prior to the election and what was actually promised in the Labour manifest. And subsequent meetings we've had with the Home Secretary and communication with the Minister for Immigration, Minister Seaman. Also, there's a Windrush Roundtable coming up on the 6th of February that's led by Windrush Justice Clinic. We will touch on that as well. But mainly, on the 22nd, the House of Commons will be about the promises that were made prior to the election, subsequent meetings and communication between ourselves and the Home Secretary. So it's just an update as to what has happened since then, the development, and how we're going to progress going forward and how we're going to engage with the decision makers. Also, on the 8th of February, there's going to be another international forum in Jamaica, and there will be others as well as we're trying to get the word out there. in Jamaica and across the world. And what we're doing in Jamaica, we're hoping to take it to other parts of the world, hopefully other parts of the Caribbean, as well as West Africa, primarily Nigeria and Ghana. Back to you, Gary.
Thank you for that. So again, everything that we are doing, the platform with all information is the Eventbrite platform. You can find all our activity, Sunday chat, House of Commons rally, International Forum, everything is on the Eventbrite platform. We've been using that platform for the last 3 years or so to promote everything we do. So always check that out. And when you Google anything, it will come up. The other important thing I'd like to mention, and we keep emphasizing this, and we will not stop emphasizing this. It's important that you use your MP. Now, your MP is there to represent your constituency. Wherever you live, whatever location it is, you should know who is your MP for your area. You should know the person by name. And if you don't know who it is, what I will suggest you do, you go to the UK Parliament website, and you will then put your city or your town, let's say Brixton, for example, you go put that into the search box, and the name of those MPs that's in that area will come up. We want people to do this because we want to raise the profile around Windrush. And, your MP is there to help and support you in any area of concern. And if people reach out to their MP more and just raise the point and ask the question, what is happening with Windrush? Or if you have a Windrush case yourself, take it to your MP. What we want more people to do this so that the MPs will see a rise in interest about Windrush issues. We want to raise Windrush concerns as a priority. We don't want MPs to forget that Windrush is still an issue. It's been resolved. No. So the reason why we had chosen to have our rallies on a Wednesday is because a lot of MP is in the House on a Wednesday for the Prime Minister question time, etc. And it gives us the opportunity to meet your own MP in the House of Commons on the 22nd of January. And don't forget, we do these every 2 months. The rallies are bi-monthly, every 2 months. So the first one for this year is January 22nd. 2 months later, we'll be there again and right through the year. But it gives you the opportunity to meet with your MP in person. And the easy way to do this is you arrive at the House of Commons in good time and you tell them that you're here for the Windrush rally. You'll be let into the house, and when you get to reception, we will be there. At reception, you go to reception and you filled in what is called a little greenie form. And that greenie form will identify your name and your MP. And if your MP is in the house, that message will get to your MP that Mr. Smith is here today, would like to speak with you. Yeah? And that is an engagement with your MP on that day. Other opportunity is that you can write to your MP anytime you want using the MP email address that you will find on the UK Parliament website, and you will send a message, email to your MP that you want to discuss this issue, or you raise any concern you have about Windrush. Why is Windrush taking so long to resolve? Why is it that Windrush is not given the priority? Has the post office scandal, as the infected blood? These are things that you can do as an individual to your MP. Ask these questions. And the reason why we're saying this is because if MPs are receiving information, more MPs are receiving information in connection with Windrush, that is going to raise the profile of Windrush issues. So please reach out to your MP. They're there to be used. They're there to serve you. They were elected to serve the entire constituency. So use them. It doesn't cost you anything. And if you want to meet with your MP in your own constituency area, you find out their surgery. What day and time is this surgery where they meet in their local authority area, and you can meet them in person. And if you have an issue that you want to discuss with them, housing, welfare, pension, whatever, you can meet them in person at their surgery. They're there to serve you. Please use them. Please raise issue with your MP about Windrush. We want to raise the profile, raise Windrush as a priority for 2025. We have a new government. We want to keep the pressure on, and we want to see tangible results, changes coming out of this new government. So please use your MPs. That brings us to the end of our session. It's now 4 o'clock. Thank you very much for spending some time this afternoon. I hope the information that's been presented to you has been helpful, that you're able to share it with other people. And as I said, you can visit our website where all the information is there, and who is eligible to apply to the scheme. You can check against the criteria to see whether or not you're eligible. And if you want to reach out for more help, there is contact information there, telephone number, email address, how you can do so. If your query is on immigration, we have links on our website signposting people where they can get immigration advice, because we do not give immigration advice. So we have access to advocacy through Liverpool Advocates for Windrush, which is the law clinic in the university, in Liverpool John Moore University. So we have access to the law clinic. If you reach out to us, we can signpost you to legal advice and support. But please do not suffer in silence and think, oh, it's no point doing this because you heard somebody says, oh, it's a waste of time, filling in application. No, we want people to make the application. And if you need help, then reach out and get some help rather than not doing anything at all. So I think that's the end of our session. Thank you very much. And we look forward to see you at our next session, which will be the end of the month, the last Sunday of the month. And if you're able to attend the 22nd of January, House of Commons, we start at 5. We want people to arrive there by 2, 3 o'clock, so you have time to get familiar with the building and, reach out to your MP. Our session starts at 5. We get into the committee room just after 5 o'clock, and we will start promptly at 5:30, and we will go through till 7:30. Then we clear the room. By 8 o'clock, we will finish. So that is the Windrush Rally, 22nd of January, 1700 to 1930. That's it. Thank you very much. Have a good afternoon. Hope to see you again soon. Bye-bye now.